Hey, how's it going, everybody? Welcome back to 2A News Now. And I really do appreciate you taking your time tuning into my video. And as always, here on 2A News Now, you get your Second Amendment news straightforward and to the point with no BS added in. The Fourth Circuit Court of Appeals intervention into a 2A case is unprecedented and just wrong. In December of 2022, a three-judge panel on the Fourth Circuit Court of Appeals heard oral arguments in a case called Bianchi versus Bruin that challenges Maryland's ban on so-called assault weapons. The Supreme Court had granted cert to Bianchi in the immediate wake of the Bruin decision, but vacated the Fourth Circuit's previous decision, upholding the ban and remanding the case back to the Fourth Circuit for a rehearing based on the findings in Bruin. Gun owners have been waiting for that panel to release the decision for over a year. But last Friday, the Fourth Circuit Court took the almost unprecedented step, was declaring it was taking the case en banc before the panel issued its decision. Mark W. Smith wrote in a tweet, "Terrible 2A News. Federal Appeals Court plays ugly game to thwart 2A rights. U.S. Court of Appeals of the Fourth Circuit Court has decided to hear in en banc the Bianchi versus Bruin Maryland assault weapons ban case, and thus prevent a likely favor 2A ruling from being issued by the three-judge panel of that court. This move was meant to take a decision declaring Maryland's ban, a violation of the Second Amendment, off the table. What other reason is there? If the panel had concluded Maryland's law does violate the rights of residents, the judges on the Fourth Circuit could have agreed to an en banc review after that decision had come down. There was no reason at all for the court to intervene other than to prevent an opinion that would have been helpful to 2A advocates from ever seeing the light of day. Even rooters acknowledged the unusual nature of the Fourth Circuit's premature intervention. The Fourth U.S. Circuit Court of Appeals on Friday took the rare step of voting to allow all 14 of its active judges to hear the challenge to Maryland's law before a three-judge panel that had heard arguments in the case in December 2022 could rule. Two of the three judges on that panel were appointed by Republican presidents. The full court, by contrast, has 8 active judges appointed by Democratic presidents and 6 named by Republican presidents. It's very disappointing that the Fourth Circuit Court took this highly unusual step of agreeing to hearing the case en banc without allowing the panel's opinion to be released. The silver lining to this is it shouldn't impact the timing of the case going back to the Supreme Court. If the three-judge panel had been allowed to issue its opinion, Bianchi was headed for an en banc review anyway, and SCOTUS has already agreed to hear the case. Once the Fourth Circuit issues its final ruling, the Fourth Circuit has tentatively scheduled oral arguments for March. But at this point, I wouldn't put it past the judges to delay oral arguments for as long as they can get away with it. Given the makeup of the Circuit Court, the en banc review is almost certain to find some spacious argument to uphold Maryland's ban. But by blocking the release of the panel's decision, it removes the ability of the plaintiff's attorneys to cite the panel and any language used to drive a stake through the heart of the state's prohibition on commonly owned firearms. It's a cheap shot on the part of the Fourth Circuit's majority, and the clearest display yet of the contempt for the court and the Bruin decision that we've seen from the federal judiciary in the wake of the ruling striking down New York's may issue law and firmly establishing the text, history, and tradition test that's supposed to be used when considering the constitutionality of gun laws. One way of describing the Fourth Circuit's actions is disappointing, but freaking ridiculous is also the apt summary of the legal shenanigans the appellate court pulled to keep a decision favorable to Second Amendment advocates from ever seeing the light of day. We can only hope when the justices of the Supreme Court eventually get their hands back on the Bianchi case, the majority opinion reserves a little bit of space to call out the Fourth Circuit Court for its appalling approach to the issue and its gamemanship with a fundamental civil right. Once again, this is another instance of a court trying to use politics to win a case, instead of what they're supposed to be doing, is using the rule of law and going by our Constitution. And hopefully by the starting of next year, some changes will be made in Washington, D.C., and these judges will be replaced by judges that follow the Constitution of the United States. As always, I would really like to hear your thoughts about today's video in the comment section. And if you guys will please continue what you always do, and that's to like, share, and subscribe, and hit those post notifications on every video that you watch. and I invite everybody back to watch my next video.